The failure of an employer to reasonably accommodate a disability. Number one, you must be an individual with a kind of major life activities that are affected, whether you are a qualified individual with a disability. Can you do the job with or without an accommodation, notwithstanding your disability? You have to be able to do the job, the essential functions of your position with or without a reasonable accommodation. For instance, ergonomic accommodations. If you can do your job, if you were given a reasonable accommodation, then you are considered a qualified individual with a disability to request a reasonable accommodation. You should make management aware that you have a medical condition that may need a reasonable accommodation. This is what the defense frequently says did not happen. No magic words are needed to make a reasonable accommodation request, especially if your disability is obvious. What becomes hotly contested is when the disability is not so obvious. Even if they know about your medical condition, they may not necessarily know that you need a reasonable accommodation. No magic words are needed. I always advise my clients, they should make it very clear. I am requesting a reasonable accommodation for my disability. Then the agency has a duty to engage in the interactive process with you. This is another common defense from the employer. They will say that the employee did not respond, did not follow up, did not engage. You see, it has to go both ways. That's what begins the process of determining a reasonable accommodation. A lot of employers fail on this aspect, but so do a lot of employees. So make sure that you are diligently requesting a reasonable accommodation and make sure that you are diligently following up on your reasonable accommodation. The accommodation requested must be reasonable without undue burden, undue hardship. You cannot eliminate essential functions from your job. There may be marginal job structures that can be altered. You do need to be interactive, but as long as you're doing your part, the agency or the employer cannot turn around and blame it on you and pass the buck back to you that you failed to communicate. Make sure that you are documenting your efforts to communicate, that you are requesting an accommodation, that you are saying, I can do this job, I just need an accommodation. I would even take it a step further and I would make suggestions as to what types of accommodations you believe would actually help you do your job. That's really the interactive process. That's for you and your employer to work out. You can tell your supervisor, you can tell human resources or employee labor relations, you could tell your reasonable accommodation coordinator, and make sure that you are diligent in following up. Reasonable accommodation law overrides whatever the agency's policies are. For example, a policy that they do not allow telework. And telework would be suitable for people who need that as part of their medical condition. They have to be willing to go around their policy, assuming, of course, it is a reasonable accommodation. You can do your job with that accommodation because you have a disability. And so they have to accommodate you. But again, you still have to be able to do the job. That's just one example. After you've requested an accommodation, they have to give you some kind of determination. They may deny your reasonable accommodation, but if they do, they have to tell you why. They have to offer you some kind of alternative accommodation if one exists. This becomes a litigated topic. Whether or not the accommodation you were given was effective. And then you have to let management know that this was not an effective accommodation. And you probably should suggest what an effective accommodation would be. Again, it doesn't have to be the accommodation of your choice, but it does have to be a reasonable accommodation. It's only after they determine that you cannot do your job, here's your last resort. They do have to perform that search for jobs that you are qualified and that you can fill. They have to be able to reassign you to a job that you're qualified for. Sometimes people don't even realize they have a reasonable accommodation claim. They may have been requesting leave, FMLA. Leave can be a reasonable accommodation if it is not overly burdensome for the employer. What are the elements of a reasonable accommodation claim? Number one, you must be an individual with a disability under the definition under the law. Number two, you must be qualified, meaning that you can do the job, you can do the essential functions of the job with or without a reasonable accommodation. Number three, you must make a reasonable accommodation request. Number four, they must engage in the interactive process with you to determine what accommodations exist. You should also engage. That is a two-way street. Then they must offer you an accommodation or offer you an alternative accommodation or a reassignment. Attorney Kevin Cran with Cran Law.